Thank you, and hello again. Yes, my topic is online infringement of intellectual property, and I'll talk about that for 40 minutes. The entertainment world began to digitalize, I suppose, in about 1980, when the music CD came in. Software had always been digital, of course, but then subsequently you had the DVD, you had computer games and so forth, and now e-books and so forth. So eventually almost everything that was entertainment or business software was a digital product. Almost at the same time, perhaps 10 years later, the internet became a commonplace popular phenomenon. And so you had the collision of the digitization of products with a global system for the distribution of digital data. And the collision of those two things produced a whole new world of intellectual property infringement, a borderless world of infringement, and that's the environment in which we have to talk about copyright piracy today. The old days of the pirated DVD are not entirely gone, but they are very largely gone. The same story, in a way, in relation to counterfeit goods. There, in place of the internet, or rather, the internet is part of the story, but in addition to the internet, we have the fact that now there is an extraordinarily efficient form of global courier companies and postal services, which mean that goods can be ordered from China and delivered here very cheaply in a very short time. Indeed, at the moment, I understand that there's some question of the United States of America leaving the Universal Postal Union because the arrangements that are agreed under treaty for the cost of international post effectively subsidize the delivery of products from the Far East to the West. And so this imbalance makes it much easier to compete, or makes it very easy to compete with local producers. So we have here developments largely to do with globalization, which mean that IP infringement has become a huge problem. Counterfeits online, we all know about that. I haven't got a lot to say about this because unless and until we can download a perfume, counterfeiting is still going to be very much a matter of physical goods. But in the copyright field, the challenges are enormous. And the purpose of this talk is to try and speak, at least from a lawyer's perspective, about some of the technical characteristics of online piracy and to try and tie them in with some of the jurisprudence of the European Court. Because it seems to me that many of the problems that people perceive about copyright on the internet are born of a failure simply to understand the basic facts. Once you understand the basic facts, you find that the copyright system, or the theoretical structure of copyright, is quite well adapted to dealing with the issues that are thrown up by these new or unfamiliar technologies. Now, this is an example. This is a very popular website, which is a file-sharing website. It's a huge collection of torrent files which allow you to share content on the internet. And I'm going to, if I have time, I'll try and explain how that works. But I refer to it at this point in order to just give a flavor of the scale of online infringement. The other day I checked how popular this website is. And according to SimilarWeb, which is a company that compiles statistics of this sort, it's about the 500th most popular website on the internet. Just think about that. It's 100% illegal website, and it's in the top 1,000. And I'm not quite sure exactly what the time period is over which, I think it's per day, but it gets about 60 million visits. And if that's per day or per week, it doesn't really matter. It's just absolutely colossal. And that's one, obviously, of thousands of pirate websites. So we also, in recent years, Sir Richard has been very much at the cutting edge on this subject, we've seen a lot of piracy of sport programming, live broadcasting being pirated. Historically, I say historically, over the last 15, 20 years, the piracy problem was about pre-recorded material, so films, music, games. Now, the hottest topic, if I can put it that way, is live programming that's being pirated as it's being broadcast. And that presents both legal and technical difficulties for those trying to defend IP rights. This is a good example that shows the scale of the problem. There was a rather gruesome boxing match that was organised between Mayweather and one of these whether they're called non-traditional boxing stars. Thank you, that kind of thing. Thank you. I defer to Richard's expertise in that field. McGregor, and they expected to sell about 4.5 million pay-per-view subscriptions to this thing. So you want to watch the fight, you pay specifically to watch on your pay TV service that fight. You pay some money. They got about 4.5 million people paying, but 132 million people watched it without paying. And that's simply extraordinary. And this interesting map was published by a technical consultancy which was measuring this thing, which shows you the blue areas where it was being consumed. I don't know if you can see there's some red dots, and that's there, and that's where the signals were coming from. People were using conventional, perfectly available streaming technology to capture the signal and broadcast it, very often using social media. Now, as I was saying earlier on, the right that we're mainly concerned with when we're talking about internet piracy is the communication to the public right. And I don't need to go through that again. The infringement types that I'm going to try and cover are direct downloading, streaming, stream ripping, peer-to-peer piracy, and then if I have time, I'm going to try and say a word about the liability of intermediaries. Now, we all, I think, understand that the internet is basically a connection of computers, which are copying machines, connected by wires or wireless means. And they're governed by software that allows them to communicate with one another according to certain so-called protocols. In a way, the simplest kind of online piracy is where someone has a website and a server on which are stored infringing copies of copyright works, and people go to the website and they click on the website and they download a copy directly. Now, of course, it's not. And then that's not a particularly difficult legal question because we've got clearly an infringement of the reproduction right. Someone has made a copy, unlicensed copy, and the owner of the website is making that copy available to the public because the website is publicly available for download. So there's an infringement both of the reproduction right and of the communication to the public right. But of course, the direct download site may not be operated by the same person who has the server with the copies on. That's the distinctive feature of online piracy, that all the elements can be distributed around the world and with different people. So this simple little animation shows that supposedly how it works. So someone, a user at home, goes to this website and clicks on a link, and the result of that is that her browser or her computer, if it's not, if it's a different protocol, is directed to the server, and quite simply, her computer asks the server to send to her a copy of the program. And where the two sites are not operated by the same person, you may require some kind of theory of secondary liability or contributory liability to make them both of them liable for the infringement. But that's basically what's happening. It's technically very simple. Now, of course, it could be a download, but increasingly, as is reflected in the licensed world, in the commercial world, people increasingly watch streamed media. That's to say, media that play to the computer without a whole copy being downloaded, and that really, from a technical perspective, is not a great difference. Data is travelling from a server where there's a copy to a user who is consuming the data. In the case of streaming, they're just consuming it frame by frame, as it were, note by note. If in the download case, they download the whole work. In this case of streaming, there's clearly a question as to whether the reproduction right is being infringed by the user. But that's, I think, still a controversial question, one perhaps that isn't discussed as much as it should be. But I want to mention what for the music industry at the moment is regarded as the most important piracy, and that is what they call stream ripping. Now, a lot of people these days, when they want to listen to music, they just go to YouTube and they search for, I don't know, eine kleine Nachtmusik, and they find someone's uploaded it and they play it. Now, the music industry's solution for peer-to-peer piracy was streaming services. And the free streaming services are supported by advertising. So bear that in mind when I explain stream ripping. With stream ripping, you use a system that allows you to get a permanent copy of content that is being streamed to your computer. So you only have to stream it once, and then you've got it, you've downloaded it. Even though the system, the originator of the stream, isn't set up to provide a download, but an intermediary allows you to create a downloadable copy. And according to the International Federation of the Phonographic Industry, which represents the record labels, 38% of consumers consume music through infringing means, and they principally, 32% of them are using this so-called stream ripping. And what happens is, it can be done in various ways, but one typical way is there's a website somewhere run by someone, and you put in a link to the YouTube video that's got the music you want, and then instead of just playing, this is my attempt to represent a legitimate site that's playing music to you, it could be Spotify. Instead of that happening, oops. I see, my animation isn't working. But what happens is in the middle here, there's an intermediary site which has software which allows it to record the stream as it's happening. And then you can, when you've heard the music, you can just download the copy. So why is this important? Well, if the solution to peer-to-peer piracy was streaming services with advertising, now there's no need for the user to see the advertising more than once. And what has happened is that advertising revenue is now being captured by the owner of the stream ripping site and not by the people who own the music. So you can see it goes to the root of the new business model for online music, and that's why it's so concerning. So the question is, legally, what's all this about? And so I adapt Hamlet to ask whether we should link or not link. And that's the question which the Court of Justice has been thinking about. I've just described forms of infringement that involve the creation of copies. But it may be that as I say, that the person who operates a website, is not the person who actually has the copies. So we have to think about what is the liability of the operator of the site in relation to those copies, whether it's the making of the copies or the making available of the copies. Now, in the ordinary case, which is the case where the site is, I should say it's the ordinary case, it's probably not the ordinary case. In the example case, where the operator of the website also has control of the copies, the position is very simple, and although this case, which was referred to yesterday, is not about this problem, it illustrates the principles perfectly clearly. You'll remember that this case concerned a photograph which a school pupil had used in a project. The school liked the project and put it on the school's website. The problem was that the photograph was not licensed for that use by the school. The photographer had licensed a travel company to use the photograph, and so the use by the travel company on its website was licensed, but the use by the school on its website of the same photograph was not licensed. And so that was although the court made it quite complicated in a way for reasons that will become apparent, viewed simply, the defendant had a copy, and they had not been licensed to make it available. And putting it on the internet is making it available, QED. Now, that would be the easy analysis where the operator of the website, the face, as it were, of the pirate operation, also has the server with the copies on. But if, as is, I think, more common, you cannot prove the connection between the operator of the site and the source of the copies, and the source of the copies may be a so-called cyber locker, that's to say an online storage facility which is run as a business by other people for this purpose. In that case, the court has had to consider what the liability is for providing links from a website to remote infringing copies. And in this case of GS Media and Sonoma Media, the court decided that the person who provides links infringes the communications of the public right in certain circumstances. Now, this case concerned pictures of a Dutch actress, which someone uploaded to a website somewhere. The defendant ran a kind of gossip website, sort of news website, and they posted links to these photographs. And the question was, the photographs were available somewhere on the internet. All that the website that was the defendant was doing was making it easy to find them. The question was, were they making available those photographs, those unlicensed photographs, that were available on the other site? And the court said, quote, "It must be examined whether the intervention at issue enables a public to be reached, which cannot be considered to have been included in the public for which the right holder had previously given his consent." So there's an idea that when a work is made available on the internet, you have some notion of what the owner of the rights had in mind. Now, in this case, of course, there were no licensed copies available on the internet, so there was no question whether there was no contemplation that other people would have access to them. The court came up with a test. It said that in order to establish whether the fact of posting on a website hyperlinks to protected works, which are freely available on another website, without the consent of the right holder, constitutes a communication to the public, it is to be determined whether those links were provided without the pursuit of financial gain by a person who did not know and could not reasonably have known the illegal nature of the publication of those works on that other website, or whether, on the contrary, those links are provided for such a purpose, a situation in which that knowledge must be presumed. Now, what that means is that where someone is operating a business, I'm running a website, I've got advertising on it, and I put links to copyright content, then it's presumed that I know that the content is illegal. I'm under a kind of professional duty of due diligence to satisfy myself that my stock, that my materials that I use in my business are legal. And in this case, a very characteristic case, the operator of the website clearly was running a business. They either knew or should have known that the photographs were not licensed, and so they were infringing the communication of the public right. But if they were not running a business, and they did not know and should not have known or could not have known that the remote copies were infringing, then they would not have been communicating to the public. That at least is what the Court of Justice thinks. Now, on social media, we find very often that streaming services are advertised, and it's a huge problem for the sports industry. This is a very famous website called Roja Directa, Spanish website, which has lots of links to live broadcasts. So when the time comes, you'll click on this link and you'll get free access to what otherwise would be a pay TV service. And this works very much the same as direct downloading, except that someone is capturing a signal using conventional equipment. They're capturing a pay TV signal, passing it to a streaming server, which is simply a computer which is set up to receive a lot of requests and to satisfy a lot of requests. And then the story is the same. You click on the link, your computer is directed to the streaming server, and the content simply streams to your computer and you watch it. And this, given if the necessary professional obligation applies, or there is knowledge or constructive knowledge, then the person who provides the website is infringing the making available right. And that's the kind of setup that you would see. You see there's each one of these represents a pay TV subscription, and this person is making money by selling access. The court has said that when you're sharing live television, if you're using a different technical method from the one used by the right holder, by the broadcaster, then we don't need to go into any analysis of whether you're reaching a new public. If it's a different technical measure, then you are making available, you're infringing the communication to the public right. This case, ITV Broadcasting and TV Catch-Up, was about a website and associated infrastructure which captured free-to-air broadcast television in the United Kingdom and then made it available to people through streaming. Now, obviously the original broadcasts were terrestrial broadcasts, so they came through the air or through cable and not via the internet. The simple fact of capturing those broadcasts and making them available through the internet, a different technical means from the one that the broadcasters were using, was sufficient to allow the court to say this is an infringement of the communication of the public right. And so what really the logic is in that, I'm not quite sure, but it's what the Court of Justice says. The reason I express some slight scepticism about this is that it's not the only way of looking at these things. There's some authority in the United States, for example, which simply says, well, if you make something available and you say that people can receive it, then there is a making available. And we don't have to worry about targeting or anything like that. But reverting to the issue of what's actually happening on the ground, one of the biggest threats for the film industry is this kind of set-top box, which they call Kodi boxes after the software that's on it. And you can buy these things on the internet already loaded with a series of apps which connect with unlicensed streaming services. So instead of subscribing to Netflix or something like that, you buy one of these and you have a massive range of free material through apps. Question is, what is the position of the person who sells the box? The Court of Justice dealt with this in a case called Filmspeler, Bryan against Willems, I should say. And Mr. Willems was selling these boxes, which you connect up to your TV. And the question was whether he was communicating copyright works to the public. And the court said that, applying the GS Media case, that Mr. Willems was running a business. He should have known that the links that he was supplying through the box, because the apps were essentially links, that those were links to illegal copies, and therefore he was infringing. And in addition, the court said that the temporary copy exception, which protects internet service providers against inadvertent liability as a result of temporary copies, that didn't apply because these were clearly illegal copies from the start, and that exception does not apply to illegal copies. The question that I would pose is, who are the plaintiffs? Mr. Willems doesn't know which of the many apps are going to be used to infringe which works. So this is extremely broad decision, which says just supplying this tool is an infringement. But how you would calculate what the damages were and who was entitled to get them, I have no idea. However, that doesn't mean it's not a criminal offence if the law otherwise permits. And in the UK, people have already gone to jail for this kind of selling this kind of box. The difficult case is where the box is sold without any apps on it. But if there's a sufficient indication that the vendor of the box is directing people to places where they can download the apps for themselves, then it comes to the same thing. But an absolutely vanilla box, as they say, doubtful whether that would be any kind of infringement. Now, I think perhaps I don't have time to talk very much about peer-to-peer download, but the point about peer-to-peer is quite simply, it's a system for sharing works, sharing digital files, which depends upon breaking up the file into many small pieces and then sharing it among many users of a specific client software that allows them to form a kind of community. And they each interrogate one another as to what parts of the file they have and then reassemble it. So at the end of the day, everybody has a copy. And this means you don't need a very large bandwidth. If you can, obviously a digital file now with a copy of a Blu-ray disc, for example, is a huge amount of data. And you'd require a very wide pipe to push all that data from one user to another. However, if you have this kind of software and you break the file up into lots of small pieces, then everybody can share the small pieces that they have until everybody's got a copy. I should mention that it's an important fact for investigators that every user connected to the internet has an IP address. I talked earlier today about domain names. Of course, the user doesn't have a domain name, but they do have an IP address that's been attributed to them by their internet service provider. And the internet service provider can usually tell the investigator, the policeman, who had that IP address at a particular time, because usually the ISP knows which of its account holders had which IP address at any particular moment. But the time is crucial because sometimes these numbers change. So if you don't have the time accurately reported, then the information may be false. Now, in a case like this, where you have a peer-to-peer facilitating website, like the one that I showed you, what's the position of the operator of the website? We know that the users are making copies and uploading copies, but we probably can't find them, or we don't want to sue them or prosecute them. What about the people who are coordinating it in the middle? Even though those people don't have any copies, and they're not directly making copies available because they haven't got any copies, are they liable for infringement? And the answer is yes. The Court of Justice took a fairly pragmatic approach, looking at a major file sharing site and said, look, they're creating a system which makes this happen. They index these torrent files, these files that allow you to identify pirate copies, and so although they didn't actually have any copies themselves, they were, in fact, making them available. And we can apply the GS Media case and say that they can't be unaware that the platform is making available pirate copies. There's a bit of a clue in this case in the name. The Pirate Bay is indeed a pirate operation. And this was the first time that people went to prison for operating a big file sharing system. And I was involved in that case actually in 2009. It was most interesting. So finally, I'd just like to say a word about YouTube. Now, YouTube is not a pirate site. It's obviously a legitimate business, very important, provides much entertainment to people. The question of its liability, however, from a theoretical perspective, has caused a lot of discussion over the years. In the typical case, we've got YouTube, which is like an enormous number of servers buried in a number of mountains somewhere, and they have users. And in my example, I have a user who has made a copy of a DVD, unlicensed copy of a DVD, and this person decides that they want to make it available on YouTube. So that's supposed to represent uploading the copy from the user's computer to YouTube. Of course, it's a feature of copying, of sharing on the internet, that everybody ends up with 100%. If I share a cake with you, I have 50% and you have 50%. If I share a file with you, we both have 100%. So sharing is slightly the wrong expression. But at all events, in this example, a pirate copy, unlicensed copy, has ended up on YouTube, and YouTube, at the request of users, makes it available to the world. Question: who is communicating to the public? Is it the user? And in that case, is YouTube contributory liable, an accessory? Or is it rather the other way around? Is YouTube making it available and the user is the instigator of it? So we would say in English, someone who counsels and procures this activity. This is something which the Court of Justice will pass on shortly, I believe, in this case, and we will find out the answer. I think that if you think about it, the question who is making available, logically, one would think it's probably YouTube, because if this person deletes this copy, this one is still made available. If this person dies, but the copy is still on YouTube and it's still being made available, someone must be making it available, and I would suggest it's probably YouTube, but the Court of Justice will tell us shortly. One case which indicates how perhaps what the answer might be is this technically slightly challenging case about a cloud-based video recorder service. Now, this was a thing where you were able to, as a consumer, you were able to arrange for copies to be made of your television programs on the cloud, on the internet, so that you could watch them later. And Vcast was an online business which enabled this to happen. They had servers, and you contracted with them, and they recorded your programs for you. So the question was, in this case, whether that was a making of a copy by the person at home, who could have made a copy on a domestic video recorder if they'd got one, or was it a making of copy and a communicating by the operators of the online business? And the court said it was the people who were doing the online business. So in that case, they would be analogous to YouTube. But I say, that's merely suggestive. We will find out. And it's a very important decision. It will be a very important decision because, of course, also in the criminal context, who is the primary infringer is often a very important element in the construction of a case. Now, this issue is very often confused with the issue of the liability of intermediaries. I'm sure that in principle, YouTube is not liable for communication to the public, not because it isn't communicating to the public, but because it is protected by one of the safe harbors under the Electronic Commerce Directive, which says basically if you're operating a business like YouTube and you don't know and have no reason to know that the copies you're making available are infringing, then you're not liable until someone tells you. It's only fair. This, however, does not affect the availability of injunctions, which Sir Richard will be discussing shortly. The protection from liability under the e-commerce directive does not extend so as to prevent a court from making an order to prevent a future infringement or continued infringement. Now, all that is about to change because under a directive which must be implemented by the 7th of June 2021, the member states must implement a new regime in relation to such large online businesses as YouTube. I won't pretend to go through this in detail now, but I just put it before you that there's a new, there's now a statutory statement that when an online business like YouTube makes works available, then it is in principle infringing the communication to the public right. So that question is resolved legislatively. However, the new directive creates a new safe harbour, so that if the service provider, if YouTube has tried to get a license from the right holder and has tried to ensure that specified works are not available on its service, and if it's notified of infringement, it prevents the infringement and prevents it recurring, then if all those conditions are satisfied, then it is not liable for the act of communication to the public. But for the sake of the law, we need to know, first of all, what is or is not a communication to the public, and then we have to decide what is or is not within the protection provided for under the e-commerce directive. And this adjustment to the e-commerce regime will no doubt give rise to many exciting and enjoyable cases for you and your brother judges and sister judges throughout the European Union. Thank you.